We thank you so much for watching Law School Made Easy at Law School Made Easy 256. Today we want to look at the doctrine of precedent, and we appreciate the doctrine of precedent. Precedents, these are cases, decided cases. And precedent literally means that when these cases are decided, then they are followed to make decisions in later cases. The doctrine of ceteris decisis is what establishes precedent. Ceteris decisis means that let the decision stay. Now, this is the leading principle in determining, in putting up the principles of precedent. Ceteris decisis has two types. It rotates around the two types. The first is what we call the vertical ceteris decisis, and then the horizontal ceteris decisis. What do we mean with the vertical ceteris decisis? In this we mean that the lower court are bound to follow decisions of the high court, of the upper courts. That if a decision is made by the Supreme Court, then all the lower courts are under duty to follow that decision. That is what we mean by vertical ceteris decisis. And then we cross to what we call the horizontal ceteris decisis. This one means that the courts can follow decisions made by it. For example, the High Court can follow its previous decisions in determining a new matter. The High Court can decide following its previous decision in determining any matter, a new matter. Precedents only occur where we have a case with similar facts. It's hard to find the cases of the same fact. The word is similar facts. We apply precedent where a case comes up when it has similar facts with a previous case. Then the judge will now be under duty to follow that other case which was decided earlier. That is what we call precedent. Now, there are principles which make up a precedent. Principles which lead us to a precedent. Number one, we have the ratio decidendi. That it is this ratio decidendi that establishes a precedent. Ratio decidendi means reason for the judgment. What is the rationale for the judgment? What was the mind of the judge when making this decision? What did the judge base on to make this decision? That is what we call the ratio decidendi. It is also very important when you are answering your problem questions, after discussing, when you write what was held in the particular case, you also include the ratio decidendi. What did the judge base on to arrive on this judgment? I want to give a ratio decidendi. Look at the case of let's say which case can explain this better. Look at the case of Karil versus Carbolic Smoke Ball. The leading judge there, Judge Bowen, in giving his assessment, his judgment, he said that where you put performance, where you put acceptance to be by performance, then you have given an offer, and in one way you have given the acceptance. That where acceptance is by performance, it means that whoever comes up and performs has accepted. So the reason for his judgment was when acceptance is by performance. So whoever performs has accepted the offer. So the reason is performance. When you give in your advert, you say the reason acceptance is by performance. So therefore, whoever performs has accepted. That is the ratio decidendi. That is what the judge based on. For example, look at ex parte Michael Matov, Uganda versus Commissioner of Prison, ex parte Michael Matov. That the judges are saying that for us as courts, we shall not interfere to question how did the government come, how did they ascend to power. For us, that is immaterial, because we are here to keep the constitution and protect it. We shall only acknowledge when there is a new order, we just follow. We don't enter into that. That's the ratio decidendi. That is what they based on to make a decision. Then another very important is the obiter dictum. Obiter dictum are those words which are said by the judge, but they don't form part of the decision, but they guide and open up the mind of the people reading the judgment and the judge himself. The analogies given. Look at the case of Ventoris, where Lord Denning gave an obiter dictum and said, if one is across the river and I communicate to him, when I communicate to that, they buy offer to that person, and then there is the sound of an aircraft up. Now, that analogy was an obiter dictum, but in Mosto, it is trying to explain to you the principles of acceptance. Then that's what obiter dictum. It forms part of the stare decisis. Then from there, we can now discuss the types of precedent. Type number 1 is what we call the original precedent. This one means that precedent has not been there. It has been created for the first time. Like, it is original. A clear example you can give here is Dr. Chiza Besigye versus Joel Kaguta Museveni. I think case number 1 of 206, which the Supreme Court of Uganda acted as the court of first instance on the first presidential election petition ever in Uganda. Now, that was original jurisdiction. That precedent was not there. But when Kizza Besigye reported Museveni that there was gross malpractice in the election, in what we call the presidential election petition, that became an original precedent. Let us go to what we call the binding precedent. These are precedents which are binding on all the lower courts. That this precedent is binding on all other courts, are under duty to follow it. All decisions of the Supreme Court are binding on all the lower courts. That you cannot run away from it. The moment you have a decision of the Supreme Court, you cannot run away from it. You have to follow it. That decision is binding. That's what we mean by binding precedent. Then let's look at what we call the declaratory precedent. Now, declaratory precedent means that the principle has been declared for the first time, but it does not mean that the laws have not been there. Quote me well. Declaratory, it comes from the word declare, that a principle has been a principle has been declared for the first time, but it doesn't mean that the law has not been in existence. I'll give a case. The case of Donnock versus Stevenson. The principles of negligence were declared for the first time, but it does not mean that the laws were not there on negligence. The laws were there, but the principle was declared for the first time. And therefore, it becomes a precedent. That principle of negligence in Donnock versus Stevenson was declared for the first time, but it doesn't mean that there were no laws. That is what we call the declaratory precedent. And then finally, the persuasive precedent. In the persuasive precedent, we are looking at cases or precedents in other jurisdictions that we can use. They don't form part of our decision, no. But they guide us on how to arrive at a decision. You cannot be in court and you quote the case of Karil versus Catholic Smoker Ball and you want the judge to base on it. It is just persuasive. It is just to persuade, to incite the judge to look at your matter. That if you look at the principles established in this case, my lord or worship, this case of a common law case of England, whichever case you cite there, those are what we call persuasive. They are only persuading the judge, but the judge cannot base on that case to make a decision. It is persuasive. And in our case, all other cases which are out of the jurisdiction of Uganda, common law cases, England, where we only use them as persuasion. Then from there, you discuss the advantages and disadvantages of precedents. They save time, they give there's certainty, and very many others. The advantages and disadvantages, I want to believe that the students will go and look on them and appreciate them so much. We thank you for watching Law School Made Easy at Law School Made Easy 256. Subscribe, share, like our videos. Thank you so much.